afternoon, or secondarily on Friday evening, I should say, upon returning from court, I was served with a secondary or supplemental report from Mr. Stoughton on matters that are completely unrelated to the use of force in terms of an audio analysis of statements that were made during the course of this trial. Ultimately, that's entirely irrelevant at this point. We're talking about the statement, I ate too many drugs, or I didn't do any drugs, whatever the statement is. The state has already introduced evidence that opposes the defense perspective on that, and it's ultimately for the trier of fact, the jury, to determine what was said when it was said, if there's any consideration of that. So at a very minimum, any testimony about that supplemental report should be excluded, as we've not had an opportunity to review how they performed this analysis. There are video demonstrations that they had submitted that slows down these exhibits in an effort to try to determine what was actually said. So we have not been afforded an opportunity to combat or contradict Mr. Stoughton's proposed testimony in that regard, in addition to it being outside the scope of what he would normally testify to, at least in this particular case. So, Your Honor, I do believe that, bringing in a sixth opinion, this was the very nature of the motion in limine at the beginning of the case, and this is what we sought to prevent. And the court gave latitude with respect to Sergeant Pluger, with respect to Lieutenant Zimmerman, with respect to allowing the chief to testify as to his interpretation of Minneapolis police policy. So at this point, and we have an expert witness who the state introduced, Sergeant Steiger, who has already performed this exact same analysis. It's cumulative, it just builds and builds and builds, and it was the very nature of what we sought to prevent.
Who would like to speak for the state?
I would.
Mr. Silver.
Thank you, Your Honor. Your Honor, the state strongly opposes defendant's motion to exclude the testimony of expert witness Seth Stoughton. As we've explained to the court in our memorandum of law, Mr. Stoughton, Professor Stoughton, comes at the use of force issue in a much different way than the other witnesses who have testified. He is a nationally recognized expert, he's an academic, and he takes an academic approach. He would not be, pursuant to the court's direction, commenting on MPD policies or analyzing those, but rather the national standards and generally accepted police practices. And this is an important distinction because, as the court knows, the defendant is not on trial for violating policies. He's on trial for violating the law. And a department can have a policy that's improper. A department can have a training that's improper, but it doesn't make it reasonable. And Professor Stoughton can speak to that. There's a national standard under Graham versus Connor. There's a standard of generally accepted police practices, and all of those fit into the constellation of what is objective reasonableness as viewed as a reasonable police officer on the scene.
Well, Sergeant Steiger spoke to Graham factors, and the chief spoke to Graham factors. Why do we need yet another person to talk about the Graham factors?
Your Honor, because he comes from a completely different perspective. And I think it's important to first focus on, when we're looking at exclusion, it'd be under Minnesota Rule 403. Cumulative evidence that would be unduly cumulative, right? That would be unfairly cumulative, unnecessarily so. So you have to look at the importance of the relevant evidence here. The use of force, or authorized use of force, is a complete defense to all of the charges in this case. And so it is primary. It's at front and center. It's important that we counter what is sort of the Goldilocks syndrome in viewing expert witnesses. This witness is too old. This witness is just an administrator. This witness is, not a national expert. This witness hasn't testified as an expert witness before, right? In order to be able to convince the jury, and we do have the sole burden of proof of doing so, that the use of force here was unauthorized and was objectively unreasonable, we need to come at it in a variety of ways. And Professor Stoughton is able to complete the last piece of that as through the eyes of a nationally recognized expert.
So what would he say? Let's get more specific. What specifically would Professor Dr. Stoughton say?
What he will testify is that upon evaluating both the threat or lack thereof posed by Mr. Floyd at the scene to the defendant and the other officers, both in terms of their own safety and thwarting law enforcement purposes, right? Based on that and based on nationally recognized best practices and police standards, the use of force here was objectively unreasonable. And he analyzes it both using Graham versus Connor, but in a four-part analysis where he identifies the force being used. He identifies the circumstances under which the force is used and the duration of the force. He looks at the effect, the effect of the force used by the officers as compared with sort of the threat posed by the subject, and then makes a determination whether that action was objectively reasonable under the circumstances. And so, it integrates Graham versus Connor, but it goes about it in a different manner, and it speaks to national and best practices standards. And it's important testimony, and it's a testimony that's central to the case.
Is your plan to show yet again the videos?
Certain segments of videos that are already in evidence as demonstrative, and these are very limited in duration, Your Honor. I'm not having him play through an entire video and comment on each and everything. What he is going to be doing is in the same manner in which he analyzes and reviews cases. So, the threat, for example, or lack thereof posed by Mr. Floyd, he would be talking about specific segments of the video that he thought were key to his analysis for that. And we select those. They're 5-second clip, 8-second clip, not an extended play. And then going through the next portion of the analysis and also commenting on whether or not the bystanders would have had an effect on a reasonable officer. We highlight certain portions of those clips too, in a not necessarily chronological order, but in an orderly fashion. I expect that his testimony won't last on direct more than 90 minutes. So it's not going to be an exhaustive play of this. Now, that's important because having read the report of the defense expert, Barry Broad, who is expected to testify, central to his report is that the crowd so distracted the defendant that he was unable to render aid and perform the normal duties that he would as a law enforcement officer. And so it's important to that issue as well, and that's an issue that's been certainly raised and suggested by the defense throughout this trial.
All right. Well, the court's concern was pretty clear before, is that in motions to eliminate, said we're not going to call every cop and ask him what would you have done differently, and basically I think the state has almost done that. We now have opinions from the chief, the inspector who was in charge of training, the lieutenant who was in charge of training, Lieutenant Zimmerman because of his seniority and that he was the responding lieutenant on the scene, the sergeant. I think the state has made its own bed here by deciding to ask all those people what their opinion was as opposed to sticking with their experts. So I think the defense has a legitimate concern, and I have a concern that this is becoming cumulative. As far as use of force, since it is more from an academic point of view and national standards, I'll allow you to call Dr. Stoughton to talk about national standards and how the use of force here violated them. I'm not going to allow you to do the crowd effect on his opinion. It's really pushing the extremes of his expertise. He's the use of force expert. He can mention that he didn't think the crowd in this case was, but he's not going to get into was a factor. he's aware of it, he didn't think it was a factor, and he can give an opinion as to whether or not the defendant violated national standards. But I don't want him getting into separate opinions about generally the existence of crowds, and he can talk about, he's aware in this case about the crowd effect, and that does not change his opinion. But we're not getting into small crowds, large crowds. This is how you would deal with large crowds. I don't want to get into that again. To the extent the defense, I'm probably giving more than the state deserves by allowing you to talk about national standards and his opinion in this case, whether they were violated, and he can talk about how he took the crowd into effect. But I don't want him talking about, like some of the experts did, about small crowds, large crowds, all that.
This specific crowd.
Exactly.
I will limit it to his this specific crowd, this specific event. We're going to be looking at the specific events here, not hypotheticals, just the timeline, his examples, and then his opinions.
All right.
Your Honor, as to the phenomena of auditory pareidolia, as the supplemental report that we gave to the defense, this is raised by the questioning of both expert Jody Steiger and of lead investigator James Ryerson, in which the defense introduced, it would exhibit 1007, I believe, and asked witnesses to opine based on what he first suggested that Mr. Floyd said. Mm-hmm. And Professor Stoughton, because he reviews so many, body-worn camera cases and has an expertise in that, and has lectured on this topic before of the phenomenon of suggestibility or auditory pareidolia, he would be able to provide not only testimony about the suggestibility and why a witness may have answered a question in a particular way, he would be able to provide an example of this. We have a demonstrative of that particular segment, slowed down, supplemented with a transcript, and it would suggest he said something completely different. Ultimately, Professor Stoughton would indicate that when he listened to the portion several times without suggestion, he was unable to discern what precisely was said.
Mr. Nelson, you want to respond to that part, since I don't think we talked much about that?
Your Honor, again, I believe that this is within the province of the jury to decide what was said. The state has already, after I asked those questions of Mr. Ryerson, they took Agent Ryerson into the hall. He listened and he formed a different opinion about what was said. And so, first and foremost, this is an issue within the province of the jury. What was said, what wasn't said, they can listen to it. They're going to be provided with the exhibits in this particular case. So it is within their province, not the expertise for him to come in. It's also important, I think, Judge, that the exhibit that they have intended to, or they've provided me that they intend to offer, is a very slowed down with subtitles showing what they believe or they think it could potentially be saying or could be interpreted as saying. So, again, we've not had any opportunity within the last 48 hours to analyze what it is that they've done, to have an expert to combat it, or to have anybody. This was completely out of left field, in my opinion. So, and given the court's previous orders on expert witnesses, I mean, what the state has done throughout the course of this case is they've introduced segments. They've attributed statements to various witnesses where certain things, you don't know if it's Officer King saying something, you don't know if it's Officer Lane saying something. The jury's not had the jury's just being told by the state, this is who's saying this. So it's the defense's right to introduce doubt, and at this point, the late hour on it is
probably. On top of which, I think it's very much a collateral issue, but I'm going to grant the request to exclude that testimony. It's not a proper topic for expert testimony. The video is what it is. The jury can listen to it. They can make up their own mind. In fact, to be honest, I was surprised that there was not an objection when Mr. Nelson asked the witness, isn't he saying X, Y, and Z? That's a witness opining on a videotape, telling the jury what they should see or hear. And that's not a proper topic for expert testimony. And the fact that you had to slow it down and use subtitles, I think, is just an indication that this is not a proper topic. It's for the jury to decide. They can listen to it. I mean, I have experience in listening to a lot of body-worn cameras. That doesn't make me an expert. I have to make factual findings off and off of body-worn cameras in Rasmussen hearings. Doesn't make me an expert, nor is it appropriate that I would, when I sit listening to body-worn cameras, I'm doing so as a finder of fact, just like this jury should. So they're going to have to listen to it on their own. They're going to have to figure it out. Both sides can argue. And both sides got their point across anyway. Agent Ryerson said, yeah, it does say I ate too many drugs. And on redirect said, putting it in context, I think it was, I didn't do any drugs. So both sides have had their say, which probably was better off in closing. But in any case, you're not going to be allowed to ask him about that stuff. Other motions we had, I think, we have Mr. Hall. We're going to deal with Mr. Hall, put him on the stand and have him either invoke and for me to determine whether or not to each specific question if it's an appropriate invocation or not. But we're doing that tomorrow, I believe. But for now, the question is, assuming Mr. Hall does not answer any questions, refuses either on Fifth Amendment grounds or just refuses the court's order, what did you wish to introduce, Mr. Nelson, and what's the basis for admissibility?
Your Honor, Mr. Hall provided an interview to Agent Doug Henning of the Minnesota Bureau of Criminal Apprehension and Agent Ricky Worry of the Minnesota Bureau of Criminal Apprehension. After the incident on May 25th, Mr. Hall left the state of Minnesota, returned to Texas, was ultimately apprehended based on some warrants that existed, was apprehended in the state of Texas, and Agents Henning and Worry traveled to Texas to interview him. At that time, I would note that Mr. Hall had an attorney who was present and was giving him advice as to providing statements about this particular incident. The statement that he provided included, just to give context of the statement was approximately an hour and a half long. He freely answered the agent's questions about where he and Mr. Floyd spent the day, what their behaviors were, where they went, the things that they did earlier in the day, and specifically how he appeared physically, what his demeanor was, etc. He then provided information to Agents Henning and Worry relevant to being in cup foods, his observations of Mr. Floyd in cup foods, and his observations of Mr. Floyd in the car prior to the arrival of Officers King and Lane. What Mr. Hall described was that instantaneously it was day and night difference essentially in his behavior. He fell asleep. They were concerned. They didn't understand why they weren't driving. Then all of this, he describes the interaction with the two witnesses who've previously testified, the store employees who've testified. He describes that they had to try to shake Mr. Floyd awake several times. And then obviously he gives testimony about what happened afterwards. There were questions by the agents about whether Mr. Floyd had consumed any controlled substances. Mr. Hall opined that was, at least in part, what was going on. He had discussions with Mr. Floyd about how these particular pills made him feel, and largely attributes his falling asleep to taking these pills.
In that statement, did Mr. Hall admit that he had provided those drugs to Mr. Floyd?
No, he was specifically asked that question by the agents. Did you give him these pills? And he said no. That was his response. Okay. And so And then he obviously goes on to describe what happens after the officers arrived and the initial detainment and his interactions with Peter Chang of the Minneapolis Park Police. And so he paints a picture of what was happening before the incident, immediately preceding the incident, and as the incident was occurring. And what reactions were happening. So we would offer, if Mr. Hall invokes his blanket or a blanket sort of invocation of the Fifth Amendment, Your Honor, I believe first and foremost the court has to analyze the defendant's, Mr. Chauvin's, right to present a complete defense and the constitutional law that stems from the right to present a complete defense when it contradicts with another person or conflicts with another person's right against self-incrimination. I also believe that Mr. Chauvin has a right to confront any witnesses that would be available to him, including trying to build his defense through those types of witnesses. Number three, the state has gone to great lengths to establish that fentanyl or controlled substances did not play a role in Mr. Floyd's death, and the state is the only party to this that has the ability to offer Mr. Floyd immunity, use immunity. Well, the court can't order it, I can't request it, but they have, at least in the chamber's discussions, stated that they do not intend to offer Mr. Hall immunity for his statements. So I think the state would have to make a showing or an offer of proof as to why they are not intending to offer Mr. Hall use immunity, at a very minimum use immunity of this statement. And the specific grounds, or what we would propose, is similar to what the court did in State versus Super, S-U-P-E-R, and I can get the site for you in a second. And in State versus Super, it was a similar circumstance where the defendant was charged with premeditated first-degree murder. A witness invoked her Fifth Amendment privileges. The state refused immunity, and ultimately what the court permitted was playing the witness's statement in court to the jury, so playing the audio of the witness's statement. And that's what we would be proposing, is to call Agent Henning to come in, explain the circumstances of the interview, to play portions of the interview that are ruled appropriate by the court, and we would offer those under Minnesota Rule of Evidence 804B3, which is a statement against penal interest, or 807, which is the residual exception, which is what the court used in the Super case, was the residual exception.
Well, let me stop you there. 804B3, the statement inherently has to clearly subject the person to such that the person who's making the statement knows that they are throwing themselves in the soup, so to speak.
Understood. And as you heard from Miss Cousins, I believe, Adrienne Cousins, Mr. Hall's lawyer here, the third-degree homicide charge is a potential charge that Mr. Hall could face if he specifically provided, exchanged, bartered, or had any knowledge of what was going on. The court has now also seen the evidence of Mr. Hall throwing what appears to be some package off to his side while the police were dealing with Mr. Floyd. So if you look at the circumstances of this statement, I mean, it would certainly be, if he were to be charged, it would certainly be a statement about what was happening in that car. And circumstantially, and from a bare minimum, it would be impeachment if he were to get up and testify that he didn't provide Mr. Floyd with the controlled substances. So, I mean, according to Mr. Hall's public defender, even acknowledging his presence, or that was him in the video, or that was him with Mr. Floyd on that date, certainly could potentially tend to incriminate him. They say everything about this case, about his testimony, could incriminate him.
Well, are you saying that the testimony that would be that he could legitimately refuse to answer on Fifth Amendment grounds, and the evidence that's admissible under 804b3 are the same?
Yes.
The same universe? Okay.
Because ultimately, Judge, if you look at the sum total, when Mr. Hall made this statement, right, which was June 2nd of 2020, so within a week, he was located and apprehended and interviewed. He was counseled by a competent attorney who gave the blessing to speak about what happened to Mr. Floyd on that day. But if you go back out and you look at, there were pills found in the car, there's a video of him throwing something, there are above and beyond just the third-degree controlled substance crimes. They do ask him questions about giving false identification. He gave Officer Lane an actual driver's license or ID card with someone's name on it. He then gave Peter Chang a secondary name, so he can be incriminating himself.
Did he admit all that in the statement?
He did.
Okay.
He had warrants for his arrest that were in place at that time, issued by the state of Minnesota, and he explains in that statement that he has had problems with the warrants, which is why he took off out of town. That's ultimately why he was apprehended as well. So he had multiple layers of. He acknowledges in the statement having a counterfeit $20 bill in his possession. So in the course of this statement, he makes several incriminating statements outside of this particular incident. As it pertains to whether he provided Mr. Floyd with the drugs, he denies it, right? I mean, he says, I didn't do it. And, if that is his position, based on how the questions that the state has presented, they intend to impeach him if he were to testify in this case with that statement. I mean, so they're using some of the very things that he claimed in his statement to either impeach him or to attack his credibility. So certainly, I think that the state has taken the position that Mr. Hall's testimony or his statement was not credible to these investigators. They have the ability to, again, offer him use immunity, and if that is their position, that the controlled substance had played no part in this case. So, when we look at, again, a defendant has a right to present a complete defense. And so when we start from that analysis, that would include investigation of facts that are exculpatory or that are consistent with his defense. And that's what this is. We look at the residual exception in terms of the 807, in terms of the trustworthiness of this statement. There are several aspects of this statement that are corroborated by Ms. Shawanda Hill. So particularly when describing Mr. Floyd's reaction in the car, she also describes that Mr. Floyd fell asleep in the car and they had a very difficult time waking him up. So much so that she called her daughter to come and pick her up. She makes statements about Mr. Floyd taking Percocets. So there is, above and beyond that, Mr. Hall was counseled by his attorney about this case and giving this statement. So,
and let me just, and maybe this is an argumentative question, although I don't mean it to be. So you're saying that his lawyer, who was advising him at the time of his statement, advised his client to give a statement that was so far contrary to his penal interests that it's admissible under 804b3?
Well, I mean, to that end, the lawyer was a Texas lawyer and may not have been familiar with Minnesota's third-degree homicide statute.
Fair enough. All right, who from the state would like to answer? Mr. Frank.
Good morning, Your Honor. Thank you. I think the court clearly sees that sort of the conflict that counsel is presenting here in saying that there are issues that Mr. Hall can testify about legitimately despite a Fifth Amendment claim, and yet those same statements are not what establish the trustworthiness that the statement against interest requires. In other words, counsel is saying Mr. Hall made statements against his interest, but those are not the statements he's trying to have Mr. Hall testify about. The statements he wants Mr. Hall to testify about, that he has asked the court to allow, despite the invocation of the Fifth Amendment, are not the statements against interest. To step back just a minute, counsel argues that he has a constitutional right to present a defense. That's true, but there are tons of cases that recognize that's true, but defendants still have to follow the rules of evidence. The rules of evidence, the hearsay rules, have to be satisfied for the statements that counsel wants to come in through Mr. Hall, despite a Fifth Amendment invocation, are covered. And the statement against interest, counsel relies on all the statements that he doesn't intend to introduce. And for purposes of the sort of catch-all exception, well, incidentally, before I get there, the statement against interest in criminal cases also requires some indication of trustworthiness before they can be admitted in a criminal case.
Well, isn't that taken care of by a court finding that it is so far contrary to the person's penal interest? That's the reliability part. Otherwise, we would have needed the second part of the rule, which says that if it's an inculpatory statement but exculpates another, you have to have corroboration. That same corroboration requirement does not seem to apply to the first sentence. And I say that to just note that it's almost saying it has to be, it's corroborated or it is considered reliable because it is so clearly and far contrary to a person's penal interest.
The statement against interest has an additional requirement in criminal cases, and that is some indication of trustworthiness for the entire statement. So it's similar to the analysis under the sort of catch-all exception, 807. And, there's a lot about Mr. Hall's statement that is